Hey there, this is LeGrand, and I've got a very important lesson for you on this one because one I get a ton of questions about, never-ending questions. Everywhere I go into a live event, people ask me, what about this land trust thing and how do I take title? So I'm going to answer those questions for you right here. So this is one you might want to get yourself out a pen and paper if you want to and take notes on this, because this land trust thing is nowhere near as complicated as people make it out to be, but it is a pretty important part of your business. First, let me start with, well, I've got the questions here, so I'm going to just ask the questions and then I'm going to answer my own questions, ones I hear a lot. First, people say, well, what is this land trust thing? All right, a land trust is a grantor trust. It's a revocable grantor trust. Now, those are words you ought to write down, because if your attorney is not on the same page, if you use the words revocable grantor trust and not land trust, you'll probably understand what the heck you're talking about. There's all kinds of misconceptions about what it is. It's not a business trust. It's not a family trust. It's not a living trust. It's not any of those things. A land trust is not used for operating an entity. A land trust is used only for taking title to a property, period. That's the term land trust. That's all you use it for. There's two parts to a land trust. Part A is the warranty deed to trustee. Warranty deed to trustee. Now, this is not a deed of trust, so don't get me wrong here. This has nothing to do with the mortgage. This warranty deed to trustee is the document. It's 2 pages. It is the document that transfers ownership from the seller to the buyer. Except in this case, the buyer is the trust, not an individual. Thus the term warranty deed to trustee. The seller is deeding the property to the trustee for the benefit of the trust or the beneficiaries of the trust. A trust has 2 parties. There's a trustee and then there's a beneficiary. One of the questions I always get asked is, who should be the trustee? And my answer is an entity that you form. And I don't care what state you live in. If it's me, I'm going to have an entity be the trustee. Don't care what entity. Don't care if the entity owns anything, because the trustee has no liability whatsoever for the trust, unless the trustee does something stupid like commit fraud or something of that nature. So you'll need a trustee and you need a beneficiary. The minute this deed is recorded, it has to be signed by the seller. By the way, buyers never sign deeds, only sellers. So the seller signs the deed, it gets notarized and in recordable form, which it is, and when this is recorded, the trust is technically established. This has language in here that indicates there is a trust that owns the property. Now, this is not the trust agreement. This is the deed that puts the property into the trust. But if this is not recorded, we don't have a trust. Along with that comes the trust agreement. Now, the trust agreement is a multiple-page agreement. And please do not be intimidated by the size of this thing, because in this entire agreement, there's only a few places to fill in the blanks. And people ask me all the time, well, do I need a lawyer to fill out my trust? The answer is, in my opinion, no. Because, you know, if you read one of these things, you'll find that you can easily fill in these blanks. It's not complicated. There's only a handful of them to fill in. The trust number, I always use the number of the house. The street address, for example, I'm holding a real trust in my hand, and the trust number is 7504. So I know that the address of this property is 7504 something. This one is my company as trustee, trust number 7504. Now, this is also the agreement that shows the beneficial interest. The beneficial interest is on the back. The beneficiaries sign it. And this is not a recorded instrument. This does not get recorded anywhere. The only thing that gets recorded is the deed itself. No one sees the trust agreement. No one knows who the beneficial interest is, and that, my friends, is one of the big benefits of a land trust. Total privacy. There is nowhere on public record does the beneficial interest of the trust show. Remember, trust agreement does not get recorded, only deed. Nowhere on the deed does it show the beneficiary's name. So the public cannot see who owns the trust. They can only see who the trustee is, and of course, if that's an entity, then there's no human involved in it as far as public records go. Now, by the way, you can get the warranty deed to trustee and the trust agreement right off Gold Club site. It's under Resources, and it's under standard real estate forms. You'll find it right there, and there's 2 or 3 other pieces that you can pull off of there as well. Now, some states your attorney will need to add a 3rd page to the trust agreement. Just show them to your attorney one time. That's all you need to do. And honestly, if you skip that step, it doesn't really matter. Because folks, the worst that can happen is you put your property into a land trust and then you have to modify it somehow or take it back out. There's nobody going to come break your legs if you do it wrong. And I'm going to tell you the reasons to do it here in just a second. So to recap, you have a warranty deed and you have a land trust agreement. Warranty deed gets recorded, land trust agreement winds up in your filing cabinet back home for nobody else to see but yourself. And that's it. So nobody knows who the beneficial interests are. All right. What are the advantages of a land trust? 1, total privacy. The trustee is on public record as trustee. Beneficiary is not there. So if someone does an asset search on you, they cannot find that you have any interest in this property because it's not on public record. My friend, the worst thing you want to do is take title to a property in your own name on public record. Actually, there's one thing worse. That's where husband and wife take title jointly in their own names on public record. If you do that, you need a flogging. Now, people ask me all the time, well then how do I fix that? Well, it's easy. Take out this warranty deed to trustee. Husband and wife fill it out and grant title to your trustee as trustee, which is your entity. Husband and wife sign it on here and you go record it. Voila! House is not in your name anymore. House is in the trust name. However, husband and wife own the trust. So you've given up nothing, but you've accomplished a lot. And let's see why. Let's just suppose that you and your spouse own the house in your own name and a smoke alarm doesn't go off and fire burns the place down and 2 children die in the fire. Well, besides really feeling bad about it, guess what's going to happen when the predators get a hold of this claim? Oh, sure, they're going to come after your insurance and they're going to max it out because that smoke alarm in that property, they might perceive it to be your responsibility to replace it. And normally that is the landlord's responsibility. So, here comes a lawsuit. You say, but insurance covers it. And then I'll say, yeah, up to a point. And then if the insurance doesn't cover it and they get a big judgment, then that judgment is going to apply directly to you and your spouse. And guess what you and your spouse own in your own name? Your property, this property, and maybe other properties. A judgment against you and your spouse jointly will apply to every asset that you and your spouse own jointly and attach immediately. My friend, if you take the time to transfer your house to a land trust, a judgment against you will not attach to a house you do not own. When your house is in a land trust, you do not own it. A land trust owns it. Yes, you have the beneficial interest, but the judgment will not attach. If you have a judgment coming down at 4 o'clock this afternoon, and you put this property in a land trust at 3 o'clock, the judgment will not attach to the house. Now don't get me wrong. Please don't assume that that's some big giant wall that the predator's not going to go through if they're actually coming after your assets. People mistake this a lot. This is only the first line of defense for your asset protection, and that's to get the properties out of your name. Because I'll tell you, an attorney coming after you, the first thing he's going to do is do a search on the internet, and he finds out that you own this property in your own name. His heart's going to start pounding, and he's going to say, I got me a dumb one here. They didn't take time to protect their assets. Immediately upon that judgment attaches to that property, now they can go and claim that property. And that also applies to anything else you got, like personal property, like note receivable, like bank accounts. That's another lesson altogether. But right now, let's get the real estate out of your name. And in the future, do not take title to real estate in your name. Take title to a land trust in all states except Pennsylvania. Sorry, Pennsylvania, but your state has really made it onerous, and you don't want to do it in Pennsylvania. Pennsylvania, they use an LLC to take title. But in all the other states, take title in a land trust. One property in one land trust. One property in one land trust. So you got total privacy, but you've also got judgments and liens will not attach to a property that's owned by a land trust if they're against an owner. So I hope you got that. So If you have property in your own name right now, simply fill out a warranty deed to trustee, fill it out correct now, make sure the legal description is correct, and you will need to put a return, or prepared by and return to on it. Get a witness, get a couple of witnesses, get it notarized, go down and record the deed, voila, done, property out of your name. Hope you got that. Then you can go home, fill out the trust agreement, put it in your filing cabinet. And you'll find that very, very simple as well. All right, so you have privacy, and you have some asset protection, and of course you've also got another little known benefit that most people don't realize, and that's ease of transfer. Now watch this. Let's suppose that I own a property, let's say it's a rental property, in a land trust, and I find an investor who wants to buy my property that understands a land trust, and many of them do. I've been teaching this stuff for 15 to 20 years now, and it's widely accepted that land trusts are what you take title of property in, even though you may not understand it, and some people you deal with, it's all over the United States. Now let's say I want to sell this property to an investor. If my investor is willing, I do not have to sign a deed to my investor. I can simply assign the beneficial interest in this land trust to my investor, and nothing changes at the courthouse, thus eliminating all closing costs if my investor is willing. So it's very, very easy to transfer. I'm not transferring the ownership of the property, I'm transferring the ownership of the trust which owns the property, and there's nothing to record at the courthouse. It's also great for inter-family transfers as well. Okay, does it work everywhere? Yep, it works everywhere except Pennsylvania. Okay, does it need a tax ID number? No. You do not let your accountant file a tax ID number for a land trust. If he even thinks about it, punch him right in the nose. Number two, it does not require a tax return. LLCs require tax returns, not land trusts. In IRS code, they are a see-through entity. The IRS does not recognize a land trust as an entity that requires a tax return or a federal ID number, nor does it have a bank account. Land trust is not a business. It does not operate anything. It's simply a way to hold title to a property. You have bank accounts in LLCs, not in land trust. All right, well, who prepares these? Well, if you're transferring a property you currently own into a land trust, you can fill this out and record it. Now, any attorney will tell you, well, let me do it, and I'm okay with that, frankly, but if you look at this thing, it's not complicated. And remember, you screw it up, don't worry about it. You can just file a corrective deed to fix it if you make a mess out of it. Nobody's going to die. All right, now, suppose I'm taking title from a seller. I'll just make sure that my closing agent is using this deed, except in a bank REO. You're going to have a hard time getting them to use this with a bank REO, but when I do a bank REO deal, I make them deed it to XYZ Corp as trustee, but we don't use this deed, we use their deed. But I still am going to have it deeded directly to the trustee, but if I can, I want to put this deed in front of my closing agent and say, please use this deed. If they want to modify it, let them modify it, because this deed does give the powers to the trustee to run the trust, where most deeds do not. All right. If your attorney is preparing your closing, give that deed to your attorney and let him or her use one they like, but why not deed it directly to the trust with the right deed? The title company the same way. All right. Well, what if my attorney poo-poos this land trust thing? Well, if your attorney poo-poos the land trust, your attorney does not understand the land trust. I can tell you that right now, because there's nothing to poo-poo. There is no downside, folks. There's nothing wrong with this land trust. And let me tell you what I'm suspecting that your attorney is thinking. First of all, he might be thinking it's some kind of like a Massachusetts business trust or something that doesn't apply in his state. That's one stupid mistake attorneys make. Secondly, some states do not have any statute concerning land trusts. So if they don't find any statute, they just assume there's something wrong with it. Bad. You do not have statutes does not mean the land trust is not viable in that state. Not true. It's used in all states, again, except Pennsylvania. By the way, you can use it in Pennsylvania. They just make it so onerous you don't want to. Okay, so sometimes attorneys think that by using this land trust that you're impenetrable by predators, and I told you that is not true. By the way, if someone is coming after you to claim on a judgment and they find out that you have beneficial interest in a land trust, well, they can take your beneficial interest, but they can't find that out by doing a public search. So the only way they're going to find it out is to call you in for a deposition and to ask you if you have any beneficial interest in a land trust. Of course, by that time you may or may not have beneficial interest, entirely up to you. But you'll find that very seldom do attorneys actually even think about piercing this land trust and going through it. But again, what do you got to lose? Is it better to have it in your name, to be an open target with a target on your chest, or have it into a land trust to where, as far as the world's concerned, you don't even own it? You know the right answer. So there is no downside to this land trust, so don't let your attorney poo-poo it. They just don't get it, I can tell you that right now. All right, well, what about my residence? My residence is safe. Well, that may be true. Look, I live in Florida, and our home is our castle here, and a predator cannot take our home for any kind of a judgment, except unless, of course, it's the mortgage and we don't make the payments. And a lot of those folks are losing their homes because of that. But if somebody gets a judgment against me, they can't take my home. Well, that's great, but still the judgment attaches. Whereas if my property's in a land trust, the judgment does not attach. Judgment against me does not attach to a house I don't own. So I'll ask you, do you want to be out there naked so a judgment can attach? How about an IRS lien? Have you ever thought about that perhaps? An IRS lien against you will attach directly to a home in your own name. An IRS lien against you will not attach to a house in a land trust, even if you own the land trust. So you decide. I can tell you, I would never own a house in my own name. Suggest you don't do the same. All right, well, should I check with my CPA? Well, sure you should. Check with your CPA. Or not. Because let me tell you something. Your CPA does not even need to know the property's in a land trust. There's no tax consequences, good or bad. There's no reason for your CPA to even know that the property's in a land trust. They don't have to report it to the IRS. There's no bank account. There's no ID number. There's no accounting. Your CPA will account for the property the same way they would if it was in your own name. So you might be doing yourself more harm than good trying to get your CPA's blessing. Well, why a land trust over an LLC? Well, here's why. A land trust is a single entity where, I mean, you could put more than one property in, but no need, no reason. It's no harder to file 5 deeds to take title to 5 properties in a land trust, in each individual land trust, than it is to put them all in one land trust where all the eggs are in one basket. And that's one of the problems I have with an LLC. People use an LLC to take title to multiple properties. Well, multiple eggs in one basket is never a good idea. Whereas if I have one house in one land trust, I got all my eggs in that one basket. So if that fire happens and those children die in my house, I'm probably going to lose that house, but it won't affect any of the other properties that I own because they're not in that same basket. So LLC is good for operating a business. It's good. It's a good entity to have a bank account in. It has to have a tax return every year. How would you like to have 20 houses and 20 LLCs and 20 tax returns? That's foolish, in my opinion. If you want, you can make your LLC the beneficiary of as many land trusts as you want, but you still have all your eggs in one not in one basket. They're in multiple ownerships, but the beneficial interests are all owned by one entity or more than one, your LLC. Okay, all right, and lastly, I'm going to end this with this. Sometimes I get people come up to me and saying, but my attorney advised me to put the title to my properties in a living trust. Oh my goodness, when I hear that, my heart palpitates and my anger increases, because let me tell you what your attorney has advised you to do, and you see if it makes any sense to you. First of all, let me suggest to you that you never, ever have a estate planning attorney prepare your estate plan without having an asset protection attorney involved in the process, because these two are kind of like a positive and a negative pole. You're going to get some horrible advice on estate planning, from an estate planning attorney when it comes to asset protection, and vice versa. They have to work together. They have to understand that the mission is to build my estate so that I pass it on tax-free or tax-reduced, while simultaneously protecting my estates from creditors and predators. And here's one of the mistakes that an estate planning attorney would make that an asset protection attorney would never make, and that's deeding a property into a living trust. And I'm going to ask you this. If you put all your assets in a living trust, and that includes your real estate, and that living trust is on title as the owner of the property, and those children die in that fire because that smoke alarm didn't go off, now guess who gets sued? Guess who gets a judgment against it? Answer, your living trust. So here comes a great big judgment against an entity that contains all of your assets because your estate planning attorney told you to title your property to a living trust. Dumb, dumb, dumb move on his or her part. You say, well, Ron, how do I fix that? It's too late. And I'll say, well, it's easy. Go take your properties and transfer ownership from a living trust individually to a land trust. If you've got 5 properties in a living trust, that's 5 deeds to 5 individual land trusts. Go record these deeds. Now, go back to your living trust asset page, and instead of putting the address of a property, now you put the beneficial interest in trust 7604 or whatever. So now your living trust owns 5 land trusts, not 5 houses on public record. And your living trust is no longer on public record as the owner of an asset because you've recorded the deed to your trustee, which is an entity on public record, and no one knows that the beneficial interest is owned by your living trust. Guys, if all that didn't screw you up, I'll continue on the next lesson. I know that was a lot, and I know that for many of you that was the first time hit. Listen, I strongly suggest you get to my business management boot camp coming up in May, I think, where I spend 3 days going over the whole art of business management, but also we get into this asset and entity protection stuff. Plus, I have a whole 2-day event taught by attorneys on this stuff. If you're interested, just contact our office. And it's taught by entity structuring and asset protection and estate planning attorneys. So we've got all of that for you. I thought I'd give you this lesson to squelch a lot of the questions I'm getting, and I hope you got a lot out of that. So anyway, I'll see you on the next lesson, and take title to your properties in a land trust. Don't let anybody talk you out of it.